Hey, hold on a minute. Hold on a minute. Hold on a minute. I don't want to talk about the motion.
Okay,
you filed.
okay, let
I
me
want
go
to talk
back.
about
I'm sorry,
your
I got off.
response. Mr.
Yeah.
West, don't interrupt me. It makes a garbled record and it's no good for anything.
Sorry.
I need you to respond to counsel's argument that he doesn't have enough facts to defend the lawsuit. That's his argument today.
Acknowledge.
Stop.
Yes.
But it's not in your complaint. The fact that they might have information about when things were sold from an outside source does not change the fact that it's got to be in your complaint.
Verdell Blackman, can you turn your camera on, please, and unmute? Thank you.
Sorry.
All right, I'll handle those whenever you're done, Judge.
Thank you. How about appearances on University Neurosurgical versus Blackman?
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Verdell Blackman.
Joey, will you come here?
Sorry about that.
All right. Good morning, counsel. What do we got?
Your Honor, this is plaintiff's motion for summary disposition under C9 and C10. Happy to make an argument if that's what the court would like me to do at this point.
Do you have it as a motion? I thought it was a pretrial. Is it a pretrial and motion?
Pretrial and a motion.
Thank you. All right. And Ms. Blackman, did you receive that motion?
Yes, sir. And I did send a response to you to that motion.
All right, let me see if we can find that.
I don't have a copy of the response, just for the record.
All right, ma'am, do you have the ability to email that response to counsel?
If they give me their email address, yes, sir.
Okay, counsel, why don't you chat her your email address or just tell it to her, and I'll give you a minute to look that over.
I'll just give it to you. It's just, are you ready, Ms. Blackman?
Give me just a second. I apologize. And what is your email address?
It's M. And then my last name, Kuipers, Kuipers.
So her response to that is what we're looking for. We don't want to see it both, but.
.law.
Wait a minute. AMKUIPER.
PERS.
S.
.law.
Dot.
@gmail.com.
Counsel, why don't you hit the high points of your argument, and then we'll give Ms. Blackman a chance to respond.
Thank you, Judge. So just briefly, this is plaintiff's motion under MCR 2.116 C9 C10. It stems from breach of contract for underlining medical services provided from April 2018 through December 2021. The defendant did file an answer, basically generally denying the claim for amounts, specifically denying one in question, which was for $3,164, and that was from January 13, 2020. There was a pretrial held, and I believe there was some discovery. Plaintiff then filed this motion, which attached all the invoices showing the complaint for amounts being sought for. It looks like the defendant did file a response, again, to the motion, again, generally denying the amounts owed or owed. The defendant has not provided any documentary evidence to support her claims, and it's plaintiff's contention under C10 that there is no genuine issue of material fact, and that plaintiff cannot rely on their mere allegations as a defense. So for all those reasons, plaintiff's requesting that the motion be granted in the amount of $4,438.10 plus costs.
Thank you, counsel. Ms. Blackman, your chance to respond.
Your Honor, I, on 2 different occasions, asked about Robert Johnson, which is the $3,000 amount that I'm disputing. I do not know who this doctor is. I've never seen this doctor or this person. I don't even know if this person is a doctor or what they are. When I called initially about the bill, I was told they would get back to me. And then Instead of getting a response back, this was sent to collections. I sent a letter to collections, again, asking about this. No response. They keep presenting a bill, but they have not presented a person that saw me. I don't even know what service I received. And because they have the location of DME Southfield, I don't know where that is. How can I pay a bill to somebody that I've never seen? It's not like a credit card where you just swipe it. I mean, somebody has to have actually seen me, right? And if I don't remember seeing this person, I don't even know who this is. I've seen Dr. Fessler, Dr. Friedel, and I've done physical therapy. I have not seen a Robert Johnson. And this is not the first time they've made errors on my bill where I've caught it. This one I did not catch until I actually received the bill. I ask that you not grant their motion because Robert Johnson is a person that I do not know. I can't see paying for a service and a person that I've never seen.
All right, you mentioned that you asked who Robert Johnson was.
Yes,
Have
sir.
you ever asked that through the discovery process to the attorney's office?
When I sent it to the attorney, I mentioned that I did not know who that was. Did I specifically ask who he was? I do not believe I did, Your Honor. I will be honest. I think I just mentioned I did not know who he was and that I disputed that cost.
Okay. Counsel response?
Your Honor, I don't see any formal discovery from the defendant regarding this particular doctor in question. And again, I would revert back to the plaintiff cannot rest on their mere denials, but must provide some documentary evidence to support their defense. And I'm not seeing that here. And plaintiff has properly pled their motion, has provided support for the medical services sought, which would be all the invoices attached as Exhibit 1, and plaintiff would again request the motion be granted under C10.
All right, just out of curiosity, what kind of document would you like her to present to document she doesn't know who that person is or what the services were?
Your Honor, I would leave that to the defendant, at least if she would have provided some type of discovery request regarding that. That would have been the document that could have been provided, but I don't believe that was done here.
Okay, motion's denied. You want to set it for trial?
Yes, Your Honor.
Heather, we got some dates.
Yep, I'm looking now. We have Thursday, June 27th. Judge, that's the day you have a 10 a.m. hearing. Do you know if it's still happening or just so that I can?
I have no idea.
Okay, so can we do the afternoon?
We should be all right in the afternoon, even if the hearing goes.
Okay, so June 27th, I have 12:30, 1 o'clock, 1:30.
And that's live, folks. June 27th in the afternoon work?
Defendant.
Your Honor, I have work obligations. I know that this is an obligation also, but this is something where they have people flying in, and that is the final day of our meetings.
I have July 8th or 9th, Monday or Tuesday.
The 9th I could work with, that Monday, the 8th or the 9th I could work with.
Attorney?
Counsel, do you have a preference? July 8 or July 9?
July 9.
All right, 8:30 in the morning?
Works for me.
I'm okay with that. Thank you.
Okay, as I said, that's live, 8:30 in the morning. Anything else we can take care of today, folks?
No, Your Honor.
All right, thank you much. We'll see you in July.
Thank you.
Thank you.
Judge, we have, are they out? Let's see, yes. The next one down, Preferred Medical versus Progressive.
Thank you. Appearances on that one, please.
Morning, Elder. Nicholas Lockman appearing on behalf of Defendant Progressive, P number 85192.
Good morning, Your Honor. Freddie Sackler appearing on behalf of Preferred Medical, the plaintiff.
Good morning, gentlemen. Pretrial schedule today?
It's a pre-trial as well as the defendant's partial MSD, Your Honor.
Oh, find the motions. All right, I'm sorry, was that plaintiff's motion?
Defendant's, Your Honor.
Yes.
Defendant's motion. All
Correct.
right,
Or I'm
go
sorry.
ahead,
defendant's
counsel. Hit the highlights of your motion.
Thank you, Your Honor, and I'll be brief to the best of my ability. As this court is well aware that this matter arises out of a motor vehicle accident on June 27, 2020. Importantly, Your Honor, this case was not filed until November 16, 2023. The partial MSD before this respective honor pertains to the 1 year back rule, otherwise known as MCO 500-3145. Now, plaintiff's own ledger does demonstrate that defendant paid plaintiff for all but the recent charges, and as such, plaintiff's only seeking the balance between the amount charged and the amount paid, Your Honor. Pursuant to the 1 year back rule, however, the claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date on which the action was commenced. As such, plaintiff would be prohibited under the plain understanding of that rule from recovering benefits incurred prior to November 16, 2022. Now, the no-fault amendment back in 2019 did apply essentially a judicial tolling to that 1 year back rule, stating that the 1 year period of limitation is tolled from the date of specific claim for payment of benefits until the date the insurer formally denies a claim. So originally, we're going to argue that the 1 year back rule does not apply, but in the alternative, if it does, then obviously the benefit would be precluded that predate the October 15, 2022 date rather than November 16, 2022. Now, the most recent barred claim is represented on plaintiff's balance sheet as October 16 of 2022. Plaintiff billed defendant on October 18. Defendant issued its formal denial on November 11th of 2022, resulting in a tolling period of 24 days. Since the most recent date of service of October 15, 2022 was 32 days outside that limitation period, it remains time barred despite that respective tolling that was brought about the no-fault amendment reform, Your Honor. But again, even if this court is persuaded that the tolling application does in fact apply to plaintiff's respective claim, the reasonable diligence is a precondition to invoking the tolling set forth in the preceding sentence. In this respective case, plaintiff waited 19 months after its respective formal denial that was received to file its respective suit, and no other apparent action was taken. By waiting the 19 months, it did not act with reasonable diligence to essentially trigger, Your Honor, that respective tolling that is allegedly applicable, if it's applicable at all. And so we're arguing that the dates of services that obviously predate the 1 year back rule from the filing of this case, November 16, 2022, should be dismissed if, again, this court respectfully perceives that the tolling application still does apply, even though plaintiff waited 19 months to file its respective actions. We're still arguing, though, then dates of services predating October 16th, 2022 would be barred under that tolling of the 1 year back rule, Your Honor.
Thank you. Or preferred response?
Yes, Judge. Your Honor, I do apologize. The internet problems inside, so I came outside. It's kind of simple, Judge. Counsel made that a lot more complicated than it needs to be. Does the court have a hard copy of my motion in front of it?
I've got one on base. I've got one on the screen.
Okay, that's fine. So Exhibit 1 to my motion, Judge, outlines, and in our motion does too, outlines our data services and what we're billing.
Counsel, hold on. You said Exhibit 1 to your motion. You mean Exhibit 1 to your response?
Exhibit 1 to our response, correct. Sorry, Judge.
That's fine. I just want to be clear. We're looking for that exhibit now.
Outlines the data services. When you get there, let me know, Judge.
Got it.
Okay. And Exhibit 1, you can see every time we invoice, our dates that we're at going back to are an invoice dated 3/16/22. That's where we're going back to. That's the date. And as you can see, which is also important here to note, judges, it's not that the plaintiff or the defendant doesn't pay our bills. The defendant chooses how much the defendant's going to pay based on what the defendant decides to pay. That's for trial, but nonetheless, they admit that the patient was injured. I mean, Judge, I think this patient's been injured for over 10 or 15 years. Serious brain injury. My client only handles brain injuries. Important to note, came to our office back in March 16, 22 to get driving transportation from us. And we invoice. And then on the EOBs, when the provider, when we send them into the insurance company, they decide to pay whatever rate they want instead of Progressive paying what they're billed. If you go to Exhibit 2 is just a case, which is right on point, which says that EEOBs are not denials. And you need a formal denial. Just like the court's aware in every other insurance world, it's not 1 year back from the date of the loss. It's 1 year back from the date of the denial, which is important.
All right, I
Exhibit
thought defense
4,
counsel said that there was a denial, formal denial.
no, there was not. Exhibit,
Okay, go
all
ahead.
all that defense counsel did was deny in an EOB. And in response to that, my client, defense counsel says my client wasn't diligent. I would like my client to go, or judge, just now go to Exhibit 4. We can skip Exhibit 3 because Exhibit 4 is as clear as day could be.
All right, give me a minute to try to find it. All right, I'm on Exhibit 4.
The court goes to the bottom of page 2 of 3. The court's going to see an email dated February 3rd of 23. From Jennifer Parker to my client. Starting, good afternoon, Rachel. And they're talking about for the 222 to the 228 billing, it appears that payment was stopped because it was mailed to the wrong address. But I was never reissued any place or quote to reissue for there will be no whatever. The second line is the most important. It's, I am still working on the rates. Prior to that, there's an email before where my client's talking to them about, hey, you're not paying us the rates that you're supposed to be paying us. If the court goes to page 1 of 3 on Exhibit 4, you'll see an email dated February 6th, 2023, where finally Progressive gets back and it says, good afternoon, I have discussed this and I am not going to be able to increase the rate. And they discuss why they're not willing to increase the rates. So the actual, my clients, and this is a formal denial. This is,
Say that again, counsel. Say that again.
So what I'm saying, Judge, is as early technically according to law, the case we attach, this is not a formal
I'm having
denial.
trouble with your audio, counsel. Your audio cuts out.
All right. Having trouble internet problems. I'm sorry, Judge. I had to go to court, so I had to be mobile today. Can you hear me better?
For the time being, yes.
Okay. Exhibit 4, email dated 6/7. Progressive says, I finally heard back and I could not change the rates. Did you hear that?
Yeah, I'm looking at the February 6th email where they explain why they're not increasing the rates. I got that.
Oh. So we then file in November of 20. We file in November of 22. So we had until that February denial allows us to go back February, 1 year back from
All
February.
right, I can't do this. I can't do this, guys. I can't do this.
Hunter, I'm so
You
sorry.
guys can come in and argue this live. You can argue this live. I'm having enough trouble trying to deal with paperwork that's not paperwork, and I can't do it if I can't hear what's being said.
Judge,
We'll schedule it live. We'll schedule it live.
I'm sorry. Thank you. It was another court. Sorry. Internet problem.
I get it. It's not your fault that the powers that be have pushed this on us. Heather, give me a date for these guys to come in.
I never have this problem.
All right. Either we have next Thursday again in the afternoon, or we have Monday, Tuesday, July 8th or 9th.
Thursday in the afternoon is fine for us, Judge.
June 27th.
Yes.
What was the July date, just so I can consider them along with the June 27th date?
July 8th or 9th, Monday or Tuesday.
Your Honor, can we do the July 8th? Is that okay?
If it's all right with both of you, I just need to get all three calendars together.
That's fine, Judge.
In the morning or
What
afternoon?
time, Heather?
I have 10 a.m. or 1:30. Or 1
1:30.
o'clock.
1 o'clock.
1:30
o'clock?
agreed?
Okay.
Yes.
1 o'clock? Where are we at?
I'm fine with
Either
that. We could do 1, Your Honor. 1 o'clock is fine.
All right. Thank you, gentlemen.
Will we be receiving notice, or is this our notice, Your Honor?
Absolutely. We'll send you notice.
Thank you so much, Your Honor.
Enjoy your day.
Have a better one. Thank you.
Judge, Mr. Ivanchek is on, and I remember you handed me a note saying something was signed yesterday.
Is this the same file, counsel? I signed I think a settlement.
Yes, Your Honor. We did do a settlement. I haven't seen it come back through as of yet.
It might not have come back through. I just signed it yesterday morning.
Fair enough.
This was credit acceptance, right?
Yeah, credit acceptance versus Macon.
Yeah, I signed it yesterday. Thanks, Heather.
You're welcome.
All right, so we're all set. Thank you, Your Honor.
All right. And then next we have
You know, you can put something in there about,
Jefferson Capital versus
whatever
Erica
that was.
Gibson.
I'm sorry, say it again.
Nope, we don't have that one. Sorry. Discover Bank versus Travis Grath.
Appearances, please.
Good morning, Your Honor. John Whitty, P66880 for plaintiff.
Good morning, Your Honor. Trevor Cruz, P73401 on behalf of the defendant.
Good morning, fellas. We got a pretrial scheduled today.
Yes, a pretrial judge. We talked. We're looking for discovery and a scheduling order, if you don't mind. We talked about 90 days, but whatever the court will grant is fine.
Oh, I'll give you as long as you guys want. What do you think you need?
90 days.
90 would work,
Okay.
yes, Your Honor.
Can we get by with written discovery only?
Yes.
Yes, Your Honor.
All right. And you want me to just reschedule the pretrial, just adjourn the pretrial out 90 days?
That's fine. Yes, Your Honor,
Good.
that works.
All right. Anything else I can do?
No, thank you.
Nothing for us.
All right. And fellas, if you're playing well together, no reason to wait until that date just to come in and say, hey, Judge, we decided we need a motion date, or hey, Judge, we want to go to facilitation, whatever. Just communicate with us ahead of time.
We will. We work together quite a bit. Hopefully we'll resolve it before the next date, Judge.
All right. So let's make it easy on all of us. Let's communicate.
Yes.
All right. Have a great day, guys.
Thank you.
Thank you, Judge.
Heather, anything else?
No, Judge, not yet. We got 2 in the
Thanks.
or 1 set in the breakout room right now.
Thank you. Quiet, gentlemen. Are we ready on Jefferson versus Gibson?
Yes, Your Honor.
Appearance, counsel.
Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the plaintiff. Thank you.
Thank you. Ms. Gibson, can you hear us okay?
Yes, I can.
Thank you. Counsel, pretrial today, correct?
Yes, please, Your Honor. Had an opportunity to speak with Ms. Gibson. We're going to send her all the documents in our possession. It's a credit card case. It looks like we might be able to settle after that. Thank you.
All right. You want me to just adjourn the pretrial then?
Yeah, that'd be great, please.
How much time you want?
60 days, if it's okay with the court, please.
Okay. So 60 days or sometime after that. Ms. Gibson, a pretrial is an opportunity for me to figure out what's going on with the case by talking to the parties. That's what I'm doing right now. So what counsel's told me is he's going to exchange some information with you. Hopefully that'll allow you two to settle the case. If not, I'll see you back here. We'll send you a notice. It'll be at least 2 months down the road. If the case doesn't settle, then at that point, we'll talk about where we're going next. Understood?
Okay. Yes, it is.
Do you
Yes.
have any questions about the process?
No, not at all.
All right, so I'm just going to make a note. We'll adjourn this for written discovery.
Fantastic.
All right, you two have a great day.
Thank you. You
Thank
as
you, Your
well.
Honor. You too. Thank you, Ms. Gibson. Take care. Bye-bye.
Thank you. Bye-bye.
All right, are we ready on West versus Gem Seal and Rutger?
Yes, we are, Your Honor.
All right, Mr. West, you are muted, sir.
Can you hear me now?
I can, thank you.
Yes, sir.
Counsel, your appearance, please.
Good morning, Your Honor. Michael Hanson on behalf of the defendants.
All right, you're representing defendant 1 and 2, correct, counsel, just to be clear?
That's correct, Judge.
Okay, thank you. And what's scheduled today?
Your Honor, it's defendant's motion for a more definite statement.
And a motion for declaratory order.
I'm sorry, say again, Mr. West?
We have a motion up for declaratory order. Under the Michigan Consumer Protection Act, we're entitled to declaratory order.
Is that something new you filed?
Yeah, I filed that through filing on May 1st.
I don't know if I've seen that. Let's see if we can find it on the computer. All right, I got your response to the defendant's motion. All right, well, let's talk. I've got Malachi here trying to find that declaratory order motion. In the meantime, let's talk about defense motion for a more definitive statement. Counsel, go ahead.
All right, thank you, Your Honor. I'll be very brief, Judge. So plaintiff has filed a new complaint on February 28th of 2024. It's a 6-page complaint. It fails to set forth any facts to support these claims against any of the defendants. It doesn't actually allege any facts specifically against Mr. Rutgers. We've provided Mr. West with the correct entity to sue multiple times, and he continues to file against the wrong entity. He fails to show also why he has standing to sue in this case. He was just the person that purchased the product. He wasn't the individual that the property was actually damaged. So without the additional facts, we cannot properly respond to Mr. West's complaint. So we'd ask the court to require Mr. West to file a more definite statement.
Can you go ahead and respond to that motion? West response. Go ahead, Mr. West. We're going to pull up your response to that, but go ahead.
Okay, my response is, first off, the complaint clearly lists 2 counts. Count 1, product liability. Count 2, property damage. And that's the second plaintiff who's been trying to get in on Zoom and it's not been allowed. And
okay, hold on a minute. Hold on a minute. You say there's a second plaintiff, but I'm looking at the case heading. Oh, okay. Hey, Heather.
Yes, Judge.
Yeah, Mr. Sanku is listed in this new paperwork.
All right, yeah, on the
Was he listed? Go ahead.
on our docket, it doesn't show up, but he is here in the meeting, Mr. West. He was never denied access into the meeting.
well, he's
I am in now.
okay.
Yeah,
Yes.
we just had to figure out who he was, Mr. West.
Okay, that's fine.
Okay.
So on with the issues that counsel has presented. The plaintiffs are bringing this complaint to the court under the Michigan Consumers Protection Act 445.901. And it's pretty extensive complaint, Protection Act. that Protection Act allows for the plaintiffs to bring the declaratory motion order when.
Okay, hold on a minute. I don't want to talk about the motion.
Okay, let me go back. I'm sorry, I got off.
Mr. West, don't interrupt me. It makes a garbled record and it's no good for anything.
Sorry.
I need you to respond to counsel's argument that he doesn't have enough facts to defend the lawsuit. That's his argument today.
Yeah, any issue that he would suggest is confusing to him, he could simply say, doesn't provide enough information to provide a response in his answer. This has been going on for a year now, and their whole issue is to discombobulate the consumer. And that brings us to, let me stay on the numbering issue. So in the complaint heading, it says count 1, product liability, count 2, property damage. And then if you go to page 4, it clearly lists product liability, count 1. And then it also even goes.
Okay, Mr. West, hold on. I'm sorry.
Go ahead.
Counsel's argument is not that he doesn't understand what theory you're suing under. His argument was that you don't provide the facts that build a case. He understands product liability is one of your claims.
Well, he's saying that I did not provide numbering in the complaint. And he cites, okay. I'm just saying we provide numbering in the complaint. We list every line numbered, and then we list each complaint number.
This is defendant's motion, defendant's response to plaintiff's response. Can you find plaintiff's response? Go ahead.
So we provided very specific and concise. It's negligence, and they sold us bad product. This is not a medical malpractice case. They sold us bad product. Simple as that. And they destroyed the product. They sold the product as new, but when they put the product in the container, it became altered, and that caused the damages. So again, they're violating the Michigan Consumer Protection Act by selling the product as new when in fact it's been altered.
Any other response?
The negligence of installing the product into a unmarked container is a violation of the Michigan Consumer Protection Act.
Which is not what we're arguing right now.
We're arguing the specifics.
No, we're arguing defense motion for a more definitive statement.
That's specifics in my world. And I'm saying that it was negligent by the party installing the product in a container that was not new. That's
all right, Mr. Hanch.
Yes, thank you, Judge.
Anything else, Mr. West, at this time on that motion?
Go ahead.
Go ahead, Mr. Hanchett. Any response?
Just very briefly, Your Honor. Obviously, the numbering that we're referencing is that he never numbered these specific allegations in his complaint so that we can respond properly to that as required by the court rules. What I've heard Mr. West say is that we sold him a bad product, but he hasn't told us when, where, or what we sold him. So that's what we're looking for in our more definite statement. And then also, I'm not hearing a response as to why the wrong defendant has been sued.
Mr. West?
I addressed both of them. Judge, this case was brought in the plaintiff number 2 jurisdiction, and the judge required it to be brought in your jurisdiction because that's where the product was sold. The product was not sold by PMGS MMI LLC. They had nothing to do with it. In fact, the plaintiff has provided this court with a U.S. Department of Transportation Snapchat clearly showing that PMGS MMI LLC is a trucking firm out of Auburn Hills. And again, this is the process that they have 5 different businesses running out of the Van Born Road address. And that is a violation of the Michigan Consumer Protection Act. Clearly, they are presenting a confusing business practice to the consumer. The defense counsel is acknowledging the confusion by saying we're suing the wrong individual. If the court would look at the letter that Mr. Lois, Chief Operating Officer, provided to the First Circuit District Court jurisdiction, it clearly indicates that, and he just said that he doesn't even know when the product was bought. And here we're looking at a letter from the Chief Operating Officer to the First Court, a District Court out of Ann Arbor, and they're saying the product was purchased on May 17th. I can't get any more specific than that. They acknowledge.
Stop.
Yes.
But it's not in your complaint. The fact that they might have information about when things were sold from an outside source does not change the fact that it's got to be in your complaint.
Okay, well, I
Mr. West,
Yes.
you have read and drafted enough complaints and pleadings to know what this is about. You need to lay out the facts that support your legal arguments so that then the defendant can respond to those facts.
Okay.
It's just the way the process works. The fact that they might know some of those things they're telling you to put in your complaint from outside sources doesn't change that.
Okay.
All you're doing is you're giving them another reason to file a motion for summary disposition and say, Judge, there's no case here because there's no facts here.
Okay.
File a proper complaint, put all the facts that support your allegations in the complaint, then they can file an answer and we're off and running.
Okay.
Now, so that motion from the defense is granted. Now let's get into your declaratory motion. Let's get into the motion that you filed.
Okay.
Go ahead, Mr. West.
Okay, I filed the motion for declaratory judgment because I respectfully submit to the court that the facts are simple enough to where we have already addressed the issue as to whether or not the material was sold by the defendant and it was defective. And the fact that it was defective should afford the plaintiffs the opportunity, or should afford the plaintiffs the right to have a declaratory judgment regarding the product, whether they knew the date or not.
All right, counsel, your response to that motion, please.
Yes, Your Honor, and thank you. I'm just seeing this now for the first time as well, but it looks like what Mr. West is claiming here in this motion is the defense has failed to properly answer the complaint. That's obviously not true. We filed a motion for a more definite statement in lieu of an answer. As for the reasons stated in our motion for more definite statement, we obviously don't have the facts in front of us as pled by plaintiff for us to reach even an answer, let alone a declaratory relief as he's requesting here. So we'd ask the court to deny this motion.
Mr. West, I'm going to deny it at this time because I think it's premature. Let's get the answer in, and then if you think that you still have a good motion, refile it.
Yes, sir.
Understood?
Yes, sir.
All right. Anything else, fellas?
Do a better job next time, Judge.
Nothing. Thank you for your time, Judge.
All right. Thank you, gentlemen. Enjoy your day.
You too.
Bye.
Heather, we got anything else ready to go?
No, I just got to bring this person in, Judge.
I'm ready. I also represent the individual defendant Hunt as well.
Yeah, don't worry about that.
Mr. Miller,
All
are
right,
you
Mr. Miller,
ready?
you still with us?
Thank you, Judge.
Mr. Miller? You're muted.
Mute. There we go.
Mr. Miller, if you have a camera, please activate it.
Where do we? It doesn't appear to be turning on here.
Okay.
Can you
And
see me?
counsel, your appearance for defendants 1 and 2.
Yes, Your Honor. Attorney Andrew Stevens for both defendants, Hunt's class and individual defendant Hunt.
Thank you. All right, Mr. Miller, today's a date and time set for a pretrial. A pretrial is an opportunity for the judge in the case, that's me, to get some information from the parties so we can move the case along, put it on the calendar. Counsel, where are you at on your end? Have you had any conversation with Mr. Miller? We need discovery. Where are we at?
I have not. I just recently got retained within the last week. I need to speak with Mr. Miller to see if he'll agree to stipulate an order for permit discovery.
Okay.
Or if not, I'll have to file a motion.
All right. Mr. Miller, we're going to throw you two in a breakout room so you can have some conversation off the record. Understood?
All righty.
Yeah. Miller versus Hunt.
Good morning, Ian. Are you ready on yours?
Yes, I don't really have much to do on this one, so I'm going to let Ms. Hillard take the lead. But once the case gets called, I will put my appearance in the record.
Thank you.
Thank you. Providence Harbor Club. Go ahead.
Your Honor, for the record, we were the attorneys of record on this matter when it was originally filed in 2018. Attorney Ian Morton, P67892. Since that point, the ownership has sold the property and we no longer represent them. We attempted to contact them, but they've been non-responsive. So at this moment, I would let Ms. Hillard to be able to communicate what the grounds of her motion are. We are not going to object or support anything. We attempted to again reach out to the ownership, but no response. So.
Okay. Counsel, maybe you can tell me, when was the judgment entered that Ms. Hillard seeks to set aside?
This one, I thought it was 1/17/2019, but let me just triple check in my system right here.
Sure. I'm assuming this is a money judgment then. She's trying to set it aside.
No, I don't believe this was a money judgment. I believe this was just a possession, but it's on her record. I'll let her speak, but I believe that, that this was an issue when it came to the improper.
Thank you. Appreciate your help. Ms. Hillard, you are muted.
Hi, Your Honor.
Good morning. So is counsel right? Was the judgment back in 19?
Yes, for me looking on the court records, that appears what it says. So the issue is that I was a victim of identity theft around end of 2017, early 2018. I've had things pop up here and there over the years as they come through. And so I did do a search for my name to see if there was anything else I needed to take care of and came across this account. And so I've never stayed there. I've never been served. I'm just completely unfamiliar. I'm sorry?
Yeah. Just out of curiosity.
Yes.
I mean, you went to a fair amount of effort to get this cleared off your record. Why?
Yes.
How's it affecting you negatively?
Well, it's something on my name that's not, connected to me. I just want my actual name to be clear. I was told to do this as a victim of identity theft too. So anything that's not, connected to me.
No, and don't get me wrong, ma'am. You don't have to justify. I'm just, for my own curiosity, I'm trying to figure out how it's affected you. So it hasn't affected your credit score. You didn't lose a job because of it or anything. It's not accurate information. You want it gone.
Correct. And I don't know how it could possibly affect me in the future. I just wanted, things to be
right. Okay. Yeah, makes sense. Sure, makes sense. Facts are good. All right. So, I mean, it's a pretty easy case for you because Providence isn't represented. They're not responding to your motion in any way because Mr. Morton used to be the attorney, but he's not now. So I'm going to grant your motion to set aside the default judgment.
Thank you, Your Honor. I appreciate it.
You're welcome. Thank you, counsel. Appreciate you logging in.
Absolutely, Your Honor. Thank you. Have a good rest of your day.
Thank you.
You as well. All right, Ms. Hillard, we'll do an order to that effect and send it out to you.
Okay, perfect. Thanks so much, Your Honor.
Enjoy your day, ma'am.
You as well.
So yeah, just let me know. We'll do an order. I'm not sure, but I think it's on that form.
Hi, Neil.
Yeah, I'm back.
All right. Better connection?
I hope so. Yeah, I don't know what happened there. Just cut right off.
All right. I'll throw you in the breakout room with the attorney.
We're back on the record on Miller versus Hunt's Glass and Jeremy Hunt.
Good morning, Your Honor.
Counsel, where are we at after some discussion?
So Mr. Miller and I spoke. I requested 60 days of discovery. He was in agreement. I'm going to send him a stipulated order and let him know I'm going to contact him by email. He has an attorney. He can have his attorney contact me. That is the path forward. If we could have a return pretrial, maybe 75 days out after the close of discovery.
Okay, all right, sure. Mr. Miller, a pretrial is an opportunity for the judge assigned to the case, which would be me, to find out where we're at, put some things on the calendar. So what I'm going to do is I'm going to adjourn this pretrial today for in excess of 60 days. The clerks will figure out what the date is. They're going to mail out a notice to you folks. We'll get together on that date, see where things are at. In the meantime, we're going to do an exchange of information. Written discovery is the phrase we use. In other words, we're not going to sit down for depositions or anything like that at this point in time. You understand all that?
I do.
Okay. And counsel, I don't need a stip in order. If you don't want one, it's on the record.
Oh, that works for me. Okay, so
I'm
just limit it.
okay to sign it if you send it in, but let's keep the work to a minimum if we can.
Perfect. Yep. So I'll limit it to written discovery only. Agreed.
Yeah, I just don't think. What are we looking at? I think it's a total claim of $6,000 or something like that. Mr. Miller, is that about right?
15,000.
15,000.
Correct.
15,000 with the additional work that had to be addressed.
Okay. All right. I missed that. So I'd be inclined to allow some depositions if necessary, counsel. But let's hold off on that until we see where the written discovery gets us.
Very good, Judge. Thank you.
Fair enough. And Mr. Miller, I heard a reference to an attorney. Are you planning on hiring an attorney?
No, I'm not. No, I'm not.
Oh, okay. All right. Okay. All right. Any questions, Mr. Miller?
I think we're pretty straightforward at this point. I'll look forward to receiving all the information and we'll proceed from there.
Okay. Gentlemen, enjoy your day.
Thank you, Mr. Miller. Okay.
You have a good day.
You too.
This courtroom got intense real quick. The judge asked a simple question. Do you have proof? But instead of answering directly, the defendant kept going around in circles. No documents, no evidence, just claims. The judge stayed calm, but you could feel the pressure building. Finally, the judge leaned forward and said, "Court doesn't run on stories, it runs on facts." And just like that, everything shifted. If you were in that situation, would you have handled it differently? She refused to pay the bill because she said she never even met the doctor. Sounds crazy, right? But when the judge asked, "Did anyone explain this charge?" there was silence. No clear answer, no proof. The judge looked at both sides and made it clear. This isn't about guessing, it's about evidence. Would you pay for something you don't even recognize?